Hello everyone, my name is Wendy Creswell. I'm a HR and Employment Law Advisor at Howard's. Just going to say I'm a little bit nervous. I've not done any live webinars before today, so please bear with me. So welcome everyone. So the topic today is termination under 2 years service. I just want to remind everybody that today's session will be recorded. If you do have any issues with sound at all, my colleague Louise is in the background. And if you just want to type something in the Q&A box, and she'll just aim to get you sorted as soon as possible. So we're going to be talking about termination under 2 years service. It's going to take about 20 minutes. And at the end, I will answer a few questions that have been posted prior to the webinar starting. If anybody does have any further questions, put them on the Q&A and we'll see how much time we've got. I'll try and answer what I can. If not, we will be looking at a Q&A document that we will send out after the webinar anyway. Alternatively, if you're used to dealing with me and you've got any particular questions, please don't hesitate to drop me an email. And I'll respond as quickly as possible. Okay, so let's get started. So when we're considering dismissing employees within a qualifying period of 2 years, the actual basic rule is that the employee requires 103 weeks of service in order to bring an ordinary unfair dismissal claim. This is because they would be allowed to include their statutory entitlement of 1 week's notice, which would actually get them over the line, over the finishing line of 2 completed years. But you should also take into account any contractual notice period if it's actually longer than the statutory notice period. The only exception to this is where the employment is terminated on the grounds of gross misconduct, because then they're not entitled to any notice. So that's not something you have to think about. In addition, dismissal is only effective when it's communicated. So when we talk about communicate, this is when the employees receive the information. So for example, if you were to terminate somebody's employment with immediate effect, but actually send the outcome letter by post, and they potentially won't get it for a couple of days, then it is at that point it's communicated, not when the letter goes out. So you just need to take that into consideration and make sure it still does mean that they're under 2 years service, and actually be prepared to be challenged as the actual termination date. So there's a common misconception that dismissing an employee who does not have 2 years service means that they're safe from an employment tribunal claim, and often leads to clients not following the usual disciplinary capability or redundancy procedures. And although that's true in many situations, dismissing an employee who does not have 2 years service is low risk. There are a range of exceptions to the rule, and I'm going to talk to you about those later. What I'm going to do is just explain what we're covering today first. So we're going to talk about fair reasons for dismissal. We're going to talk about automatically unfair dismissal, discrimination, breach of contract, subject access requests, and best practice within and after probation. And then finally, I've just got a couple of case studies that I'm going to read out to you. Okay, so I always think a good starting point for this type of topic is to look at the fair reasons for dismissal. So for a dismissal to be fair, the employee has to show that the employee was dismissed for one of the following 5 permitted reasons, which is capability, conduct, redundancy, statutory illegality, or SOSR, which is some other substantial reason. So where performance is relied upon as a reason, dismissal is likely to be unfair unless a capability procedure aimed at bringing the inadequate performance to the employee's attention and giving them the opportunity to improve has been followed. Conduct issues range from failure to follow lawful instructions to engaging in activities outside the workplace that damage the employment relationship. An employer can dismiss in misconduct cases even if the reason does not amount to gross misconduct, but you are actually obliged to give notice and follow a procedure, including warnings, which are fair overall. Where there's been gross misconduct, no notice needs to be given, but fair procedure does need to be followed. Redundancy dismissals may be unfair where there's failure to follow an appropriate procedure. This could be because the employer's failed to adequately consult, has followed an unfair selection procedure, or has failed to consider alternative employment. Unlike disciplinaries and grievances, the ACAS code does not apply in redundancy situations. Okay, so statutory illegality, because if the employee could not continue working in the position without contravening a duty or a restriction. For example, a bus driver who loses his driving licence, and so he cannot continue to drive. However, in such a case, an employer might be required to consider whether there's any reasonable alternative non-driving work that could be offered for the duration of the ban, rather than dismissing. Some other substantial reason is a catch-all category, which provides a potential fair reason for dismissal where the circumstances cannot be classed as one of the other potentially fair reasons. The following could amount to SOSR dismissals: the dismissal of a person employed on a temporary replacement, the dismissal of an employee who's been imprisoned, dismissal resulting from the employer losing trust and confidence in the employee because of something that they've done outside the workplace. If an employer can show dismissal was for one of the fair reasons, whether or not it was fair or unfair depends on whether the employer acted reasonably or unreasonably in treating the reason as sufficient for dismissing the employee. Tribunals will take the size and admin resource of the employer into account as well. So depending on the circumstances, factors which could be relevant would include, for example, whether the ACAS code's been followed, take into consideration the length of the employee's employment, the reasonableness and thoroughness of any investigation, the extent to which the employee was warned and given the opportunity to improve in performance concerns, the extent to which the employee was given the opportunity to give his or her version of events before a decision to dismiss was taken, consistency of treatment with other employees, whether the employee was considered for other roles in the organisation, for example, redundancy, and finally, the employer's actions will be judged on the basis of information that was available at the time. So what I've just gone through is what you should consider with employees with over 2 years service. However, there is a perception that you can dismiss somebody with under 2 years service without risk. And I talked about this earlier, and I said we'd mention it, the exceptions to the rule. Therefore, if the dismissal is for one of the automatically unfair reasons, then no qualifying service is required to bring a claim. And these exceptions are actions on health and safety grounds, asserting a statutory right. So, for example, requesting equal pay or an itemised pay slip. Reasons relating to pregnancy and maternity leave. Refusal to work over 48 hours a week. That's part of the working time regs. Making a protected disclosure, so whistleblowing, and making a request for flexible working. There are others, such as selection for redundancy, for any of the automatically unfair reasons. When we look at discrimination, the Equality Act 2010 provides protection against unlawful discrimination, harassment and victimisation for the protected characteristics. These characteristics are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion and belief, sex and sexual orientation. Where someone believes that they've been dismissed because of a protected characteristic, it may give rise to a discrimination claim. And actually, in some cases, it can also be automatically unfair dismissal. So as I said, clients often think that because sometimes someone has under 2 years service, then it's safe to dismiss, and often do not consider the risk of discrimination. So we'd always say, if you're looking at dismissing somebody, always call us first. That's what we're here for, and we'll give you the right advice and just outline any potential risks as well. So let's go on to talk about contractual procedures now. So more explicitly, breach of contract. So when could an employee claim a breach of contract through a dismissal process? Irrespective of length of service, if the company's policies are contractual and you do not follow those when dismissing somebody, then although they can't claim ordinary unfair dismissal, would actually put a breach of contract claim in for failure to follow such contractual procedures. Another complication may arise if you look to dismiss without following a process. Is a disgruntled employee out for revenge and puts in a subject access request. And these can be a really timely exercise in itself, I suppose, depending on what they've requested. Okay, so just going to go on to talk about best practice within and after probation. So looking to dismiss within a probationary period is a lot more flexible than when the probation is completed successfully. However, again, considering whether your procedures are contractual, there is a risk of breach of contract claim. So you should always be confident in your obligations. Where procedures are non-contractual, you have choices on how you deal with performance and conduct within a probationary period. From an extreme best practice point of view, we'd suggest that if you were considering dismissal, firstly, meet face-to-face in a probationary review setting, discuss your concerns and allow the employee to respond. The main point really is to try and establish whether the concerns are of a conduct or capability nature, and therefore knowing how to deal with the situation. It would be a choice whether you allowed somebody to be accompanied and whether you invite them in writing or just bring them into the meeting. From a capability point of view, there'd be a number of options. Do you extend the probation and give them the opportunity to improve? We'd always say that's best practice, and you could do that through a performance improvement plan. Or do you dismiss? This can be done at any point during your probation, but just remembering to explore the capability issues, ensure there's no underlying reasons for any underperformance, such as a disability. Otherwise, dismissal could be discriminatory. When you're deciding on action, again, you could meet face-to-face or just write with an outcome. If you're looking to dismiss, would it be fair to offer the right to appeal? Well, that will be entirely up to you within a probation. Irrespective of whether they are in the probation period or not, or just have under 2 years service, employees have the right to be given a written reason for their dismissal, irrespective of whether your process is followed, just to avoid any risk of breach of contract. From a conduct perspective, the argument is, do you follow a disciplinary process? Of course, you can look to dismiss without, but just check your disciplinary policy, see if it's contractual, and any clauses around forfeiting a process during probation in your contract. Otherwise, again, it could be a breach of contract. Also, would it be fair to dismiss without at least having an investigation fact-find meeting? We'd always suggest it's just to eliminate any discrimination risks, and then ultimately be your decision whether you were to dismiss after the investigation or continue and hold a disciplinary. Once somebody's completed the probation but they're still under 2 years service, you can no longer rely on the flexibility of terminating failed probation. Yes, you can still decide not to follow a process as long as those processes aren't contractual. You cannot claim ordinary unfair dismissal, but the risks still remain of discrimination. So just something to bear in mind. We'd always advise to follow a process in line with ACAS best practice, which in essence is fair investigation, the right to 48 hours notice for a formal hearing, the right to be accompanied, and the right to an appeal. The implications of a successful appeal may result in reinstatement, which may give continuous service. And if following their reinstatement, the employee chooses to resign because of that original dismissal, this could tip them into the 2 years service and above, with the ability to then bring a claim for constructive unfair dismissal. Okay, so the final part of the webinar before we go on to any questions is really just a couple of scenarios that I was going to read out to you. So the first one is a recruitment consultancy manager was summarily dismissed for gross misconduct just 2 days before she 2 years service. Needed to bring a claim for unfair dismissal. The employee did not follow a disciplinary process and she was not given the right to appeal. The employee claimed unfair dismissal. The Employment Tribunal had to decide if she had the 2 years continuity of service to be eligible for a claim. Employees can normally add on the statutory minimum period of notice to the effective date of termination if the employee has not been given the proper period of notice. The tribunal said that she should have had 1 week statutory notice, the unfair dismissal claim could proceed, and that the employer had acted unreasonably. The employer had failed to investigate the alleged misconduct and failed to follow a proper procedure before dismissal. So that's one of them. I'll just go on to the last one now. An employee was dismissed in a letter which was sent special delivery and signed for her son on the 30th of November. He had been expecting the letter to arrive, but she had to go away for a few days because her sister was giving birth. She did not open the letter and found out about the decision until the 4th of December. She brought a claim for unfair dismissal on the 2nd of March the following year. If the effective dismissal date was the 30th of November, a claim would have been out of time, but if it was the 4th of December, it would have been in time. The Supreme Court held that the effective dismissal date was the 4th of December when the employee opened the letter. She should not be criticised for letting her letter stay at home unopened, instead of getting her son to open it and read it to her as the contents were private. She'd not deliberately failed to open the letter or gone away to avoid reading it, and therefore the dismissal date should be the 4th of December when she found out about the decision. The Supreme Court also held on policy grounds it was desirable to favour the employee in interpreting time limit provisions, and that strict contractual laws concerning contract termination should not displace the statutory framework. Okay, so that's the end of the webinar. Thank you for bearing with me, and thanks to all those that have shown an interest. We did have a few questions that came through prior to the webinar, so I think I've picked 3. I'm just going to go through now, and then what I'm going to do is have a look if anybody's put any questions on the Q&A and see if we can get a few answered. Okay, so the first one that came on was, if company finance improves and allows for re-employment in similar areas, how quickly can a post be advertised? And is it just a case of offering the person initially made redundant back to interview alongside fresh candidates? Or is a company duty bound to reinstate them to the vacant position? Okay, so if somebody's been made redundant but they are actually still presently working their notice when you realise that you actually need to put that position vacant again, then you would be duty bound to give them priority. Otherwise, there'd be a risk of an unfair dismissal claim because ultimately the redundancy wasn't genuine. If, however, this is post-termination, there's no time frame on the limit to advertise again or to give the terminated employee first refusal, although they could apply for it if they wanted to do. The only risk here is that as an employee, you can make a claim for unfair dismissal within 3 months of termination. If you were to advertise in that 3-month time frame and they saw the post again, then they may consider it was not a genuine redundancy and may look to make an unfair dismissal claim. But I think as long as you can evidence that the situation had changed and it was actually a genuine redundancy at the time, this lowers the risk. Okay, second question. What if an employee is taking sick leave but she doesn't want to come back to work? How long can she be on sick leave for? What can I do to get her back to work? Can I terminate her whilst on sick leave? She has been less than 2 years service. I mean, there's no limit to sick leave. Ultimately, they're only entitled to 28 weeks of SSP, but there's no limit of how long they're going to be on sick leave. But we always suggest that it's best not to let things linger, and after 4 weeks, ultimately it's classed as long-term sickness. So that would be a point would be suggesting that you'd be holding a welfare meeting with them, discussing intentions and what adjustments you can make to get them back in. On the back of that, if it was a disability they had, then you'd be under an obligation not to just consider reasonable adjustments, but also to seek medical advice, how you can support them and get them back into work. Because if you were going to go down a capability route and look to dismiss on the grounds of medical capability, and you hadn't put these things in place, then ultimately there are risks of a discrimination claim. So it's just things that you would need to go through that process, and we'd always say pick the phone up to us and we'll talk you through it. Okay, last question is, could I ask how probationary periods, disciplinary warnings are affected by the lockdown period, if they've expired during that time? I mean, this isn't really a dismissal question, but it's something that we've been asked on a number of occasions where people are within the probationary period, for example, on furlough. And it, you know, ultimately means that you can't monitor the performance. So if you've got a clause in your contract that gives you the right to extend a probation, and you could do it on that basis, ultimately saying that you've not had a chance to fully assess their ability to do the work, and therefore you'll be extending it for the same amount of period when they return. Alternatively though, if there's no clause in your contract, you could have that conversation with them to explain that you're looking at extending it on that basis, and that would reduce any risks of a breach of contract if you did. Again, with disciplinary warnings, you could look to extend it. If you've got a disciplinary policy which is contractual and there's no provisions in place, then obviously there would be a risk of a breach of contract. Okay, so I'm just going to have a look and see if there are any Q&A questions. Give me a moment. Okay, yeah, so we've got a couple. The first one's just asking for advice on making redundancies for staff with under 2 years service. Again, we'd say to follow a process. It's a very difficult one to give advice because redundancies are quite complex. I'd need to know a bit more information about what your intentions are. So whoever sent that through, it might be worth just giving us a call on the office number and we could talk that through. Okay. I want to dismiss someone, but they have gone on sick leave. How do I proceed? She hasn't been with us for 2 years. Again, it'll depend on what she's off sick with and what process you would need to follow to look to dismiss. It's very much like the capability that we were just talking about. So if they did have a disability, then ultimately you're going to have to go through a process. Otherwise, yeah, there's obviously risks for dismissing somebody who's off sick. If it was just short-term persistent absences or just high levels of attendance, then yes, maybe. If they're off sick, we'd ultimately suggest you don't do it until they're back. But with under 2 years service, the risk is low. But the person who put the question up, if you want to give me a ring, we can talk through your scenario in a bit more detail, if that's okay. Okay, so that's sort of me done for now. I'm going to hand you over to my colleague Louise. Again, if there's any more questions do come through and you think of any, just drop me a line. Yeah, Louise is going to talk to you about any up and coming events and any further support that you need. So it just leaves me to say thank you everyone, and yeah, have a good day. Okay, bye.
Thank you, Wendy, and thank you everyone for attending. So just to finish off, really, you will all receive an email in the next day or two max, which will have a Q&A document with any questions and answers that have been sent in, and also the recording will be sent through if you do want to rewatch it or have any of your managers rewatch it as well. And we will ask for feedback, so any feedback that you can send through is greatly appreciated. Now, I know Wendy touched on it, we have got a good mix of clients and non-clients events online today. So any clients who require further advice, if you just pop your advisor an email or give the office number a call. Anybody who isn't a client that wants to discuss further support, if you email me at louise@howards-uk, or call the office number on 01274 864 999, and we can have a chat about your requirements and what's needed. So just in terms of how we can help, so we help businesses with ongoing employment law, HR and health and safety support. So everything from documentation and advice through to on-site support for things like redundancies and even COVID-19 audits and risk assessments. So just drop us a note if there's anything you want more information on. And finally, our next event coming up is a live Q&A again, which went down really well last time, which is after furlough ends, what next? And that'll be on things like company funded furlough, layoff and short time working, sabbaticals, and that's going to be presented by Gavin Howarth, our Managing Director, and Charlotte Geeson, Head of Employment Law and Business Immigration. So that's the 1st of September. There's a 10 a.m. session and a 2:30 session. So you can either register on our events page, or you will all receive an invite by email, and you can register that way as well. So thank you all very much for attending. I hope it was helpful, and we'll look forward to seeing you again soon. Take care.